All right. Hi, everybody. Welcome. My name is Anthony Volin. I am the owner and broker of The Collective. And I'm here with, well, on Zoom, our multifamily and commercial director, Will Tiao. We're super excited to have you guys. We have a great speaker today, an eviction attorney who is one of the most popular, one of the best that we have in our city, and we're super lucky to have him today. There's been a lot of changes going on between landlord and tenant laws, and we want to share that information with you today. Marshall, do you mind shutting the door? So we want to share that info with you today. Like I said, I'm Anthony Volin with The Collective, and we're very passionate about bringing education to the public, to our realtor friends, to all of our vendors as much as we can. This particular session is part of our multifamily meetup. So if you're interested in joining the group, you're welcome to. It's multifamilymeetup.com or LA multifamilymeetup.com. And you could join our meetup group to be part of our list and be aware of all the upcoming sessions we have. We also have all of our past sessions on our YouTube channel. So if you search The Collective Realty on YouTube, we have a playlist just devoted to multifamily investing. We have different speakers every single month. So every month we're meeting hybrid like we are today. Some of you will be on Zoom, some of you will come in. Our office is in West Hollywood, so we always love to see people come in and just a different type of networking experience, and love to have you here for that. And I'm going to give just a quick touch on the residential market, a quick update on things that I've been seeing. So first thing that everybody always asks is, how are interest rates doing, right? What are interest rates at? And interest rates, they're asking because it is something that affects our market. And it has for this last year. Interest rates now are still in the upper sixes. And we were hoping they would start to come down a little bit more. We saw them come down to the mid sixes, maybe a little below that. Then they went back up to the upper sixes. And it's kind of going to be around the same thing for a while. Most economists that I've been talking to see a path for interest rates to come down towards the end of the year. We all heard that the Fed say they're going to lower the Fed rate 3 times this year. But remember, that doesn't always directly correlate to mortgage rates. That has something to do with it, but 10-year bond is a much better look. So we do still expect later this year that mortgage rates to come down to the low sixes and possibly high fives. That's kind of like the sweet spot that we think will also loosen up inventory, where it'll give sellers more confidence to sell and buy something else. So that could be a very busy market. If that does happen, expect prices to go up. Prices right now in most areas are continuing to go up. I know on the east side of LA, if you're looking for a starter home, things are selling for 100, 150,000 over asking price. It depends on the neighborhood that you're in. So definitely, you need to research your neighborhood. This is again for residential. It seems like condos are a little bit slower, like they have a little bit of lag. And maybe the high point for condos as far as prices was about a year ago. They've come down a little bit and are kind of staying steady, but are not going over asking in most cases. But they're still selling pretty quick if they're done and priced well. Things have to be priced really well. So that's kind of a quick overview of the residential side. Today's session is all about multifamily. So we want to keep our time mostly leading to that. I did want to mention one other thing. Maybe actually, I'll have a couple updates I'll give after I turn it over to Will, our multifamily director, and go ahead, Will, take it over from here.
Thanks, Anthony. Hey, everybody, welcome. As Anthony said, I am Will Tiao. I am the Director of Commercial Real Estate here at The Collective Realty, and I am also the co-owner of Tiao Properties. And we focus primarily on multifamily properties, multifamily and mixed-use properties. On the brokerage side, we do property management, and we're investors and developers as well. So this is really our space. Today's an important day, Anthony. I don't know if you realize this, but we hit 2,300 members today in the LA multifamily meetup. That is obviously a pretty decent sized number. And we've been doing this now for, gosh, Anthony, how long have we been doing this? Like 7 or 8 years? Something like that. You're muted right now. So anyways, thank you all for joining us. Some of you I know are here for the first time. Some of you have been with us for a long time. So it's all great to meet you. It's a great group of real estate professionals, as well as investors and landlords and property managers, all sorts of different types of folks who are in the multifamily space. And as Anthony said, we always try every month to bring in a new speaker who focuses in this area. Our speaker today, Niv Davidovich, is one of the best when it comes to this particular area, landlord-tenant relations. And we're really excited to have him on board. So before we start, I usually like to give a quick, kind of multifamily update on what's happening in the multifamily market, just as Anthony just did on the residential side. So, very similarly, like obviously interest rates have really affected the multifamily market, particularly over the last year and a half, almost 2 years now. But the other major thing that's really affected, I think, the multifamily market as well is the legislative landscape. A lot of investors are finding it much more difficult to basically rent out their spaces without running into some regulatory issues, as Jay Wu of Highly Realty was saying at the beginning. It even affects some single family homes, which you didn't used to, right? And now, people are being affected on all sorts of levels. So we're seeing some churn in the multifamily space. We're noticing that cap rates are going up. I'm seeing things that are listed at 5 caps, 6 caps, sometimes 7 caps, depending, of course, on the area. We all know, if you've been involved in our multifamily meetup, you know how cap rates work. The lower the cap rate, usually the better the area. So you go towards the ocean, tends to be lower cap rates. You go east and south, you tend to get higher cap rates. But we have definitely noticed an increase in cap rates, and we're seeing that in closings. That said, since the beginning of the year, we've also noticed a lot more inventory coming on the market. There's been a lot more listings, and we're starting to see some sales close now. We're in the process of that right now. So let me share with you a little bit of what we're working on. It's a good demonstration of what's happening in the market. So can you guys all see that? Let me make the view full screen. Okay, so this is a good example of like what we're seeing in this market and what we've done. So this is it's a 10 unit we listed at the big, not like in February, for it's a 10 unit multifamily, heart of Pico Robertson, a mix of 1 bedrooms and 2 bedrooms. We listed this, Ken Dennis, I saw you on the line. What was the cap rate we listed this at? It was like I want to say we definitely listed it in the 5s. It was a 5 cap. It was over 5 cap. Hi, Ken.
It was over high. It was over 5 cap. Yeah.
Do you remember what it was? Like 5.3? Is that right?
Something right around there. Yeah.
Yeah, it was like around 5.3 cap. Ken works with me on the TR Properties team, and so we put this on the market. So just a little story of how we even got this listing. This is very classic for us. Family comes to us from Texas. They own this building. The wife is originally from this part of LA, has owned this property for a couple generations. We manage the property for them. They have various issues throughout their time, both maintenance as well as with tenants. We work with them. When it comes time to sell the property, they come to us, and we put it on the market for them. The mother passed away, so they got the step-up basis. So they decided that they wanted to, it says that my screen is paused. Can you guys still see what's going on?
Yeah,
Okay.
we still see the yep.
Okay, good. So anyways, so we manage it for them. Mother passes away. They decide to take the step up basis and move their money out of California, which, like I said, we're starting to see more and more of. And we get them multiple offers, all at asking or above. We get them into escrow with an all cash deal. And we're about to close on this at the end of this week. And it's, so this is a classic example of the type of thing we do is we do a lot of management as well as a lot of sales, particularly in the space. But, definitely like when we priced it, we were, like everybody, we were seeing price drops in the market. We're seeing cap rates go up, but we had priced it correctly because, like I said, we had multiple offers at ask, and we even got one slightly above, and we were basically able to and we're going to close just slightly below asking. So, this is an example of what we're seeing in the market is that we are starting to see buyers come back, but it's not, it's not the crazy times of 2 years ago, right, or 3 years ago. But, we are starting to see people kind of adjust to the new interest rate environment. I would say,
So Will,
yes,
sorry
sir.
to interrupt. Like, so 2 or 3 years ago, right? What do you think the cap rate would have been for this property then?
It probably would have been in the fours,
Yeah,
you know?
yeah.
So and we wouldn't have had to give any credits or any of those types of things, like that's where we're at. And the other thing I would tell everybody is insurance. Trying to get insurance on older multifamily buildings is becoming a very difficult thing. I think that's generally speaking, right? The insurance market in real estate generally is tough to get even for single family in some places, but particularly for multifamily, if you get into a deal on the multifamily side, start looking for insurance right away. In fact, the current insurer, State Farm, wouldn't insure the new buyers. So they had to go get new insurance. I want to move on to another. So this
Your
is
screen, your screen is froze on ours.
Oh,
It's on
now
page
it's
1
frozen.
still.
Okay, let me
Yeah.
try to do this again. Huh. Not sure why it's doing that. Oh, exit. Click exit. Full screen. Okay. Let me try it this time. Okay. Can we see it now?
Yes.
Okay, great. So this is a duplex in the Silver Lake Virgil Village area. And so this is 2 units being delivered fully vacant. One's a 3-bedroom, 2-bath. The other's a 2-bedroom, 2-bath. What we're seeing is there's a lot of interest in this because, well, for 2 reasons. One, it's vacant, and a lot of people like vacant properties because it's potentially owner occupied type of thing. But also there's development possibilities. You could build 2 detached ADUs in the back. I found that out from our first speaker of the year, who was a general contractor who took a look at this property. So you could build 2 detached ADUs in the back. There's like space right now for 6 parking spaces. So that's why there's a lot of room in the back.
Yeah, and Will, like a lot of investors that I've been talking to, this is what they're looking for. They're looking for something that has room to develop and to grow and to put ADUs in and more units. That's like their focus right now, is that value add. So if you're an investor, you're going to be think about that before you purchase something. Or if you own something, is there something maybe you can do to develop it a little bit more? We have some great contacts that can help you figure that out and decide how many ADUs you can put in with the junior ADU. Are you using SB9 as well? And how what's the max you can put, and how does that increase your value? Those are things to look at as well. And Will's going through his personal deals and listings, but please note, like, this is to help all of us understand, what's out there right now, how realtors are thinking about pricing properties, how that's changing, what's important when you're purchasing an investment property, and so on. So, if you're not looking to purchase something right now, use this as education for what's out there in what area right now and what that looks like.
100%. Yeah. So the people who are looking at this are thinking, okay, here it is vacant. I could potentially owner occupy it or just get the income while I'm developing these two ADUs. Or the other option is it's commercially zoned. So you could technically tear this down and build 9 units there. So that's another option for kind of more sophisticated people who are looking further down the line. Another thing that I'm seeing a lot more of, and that this property also has, is an assumable FHA loan. So you could take over the seller's loan, which is at 3.25%, which, as Anthony said earlier, right? That's half or less than half of what current interest rates are. So that's a big potential bonus for somebody if they're interested in assuming over this loan. And I'll put more information about this if anybody's interested in this particular property.
And that is a bonus, right? Like if you see that a FHA loan is on a property or someone's advertising it, they're probably not building that into the price, but because not everyone's going to do that, but it's an option out there. And if you do, and you have one loan that's the assumable loan and then another loan for the rest, that's a bonus to get half off on your interest rate. Yeah. And not all loans are assumable. FHA happens to be one that is, yes.
Yep. Okay, and so this is my last one. And this is a true, I think, development play, which is to say, like, it's currently a triplex. One unit will come vacant. There's 2 units on the property. They're all 1-bedroom units. And 2 of the units do have tenants in them. But because of the way it's zoned R4. So you could actually tear this down and build 24 units on this lot. That's obviously, you know, a massive value add. This is not on the market yet.
And if you do want to build 24 on that lot, you should talk to Sherry Bonstell, who's on the
there
call.
we go. Sherry Bonstell's your land use attorney. She's my personal land use attorney. Okay, so and obviously we have connections on all these areas if you need any support in that. But Sherry's definitely the person to ask. But yeah, so if you're looking at building, you know, if you're interested in something like this, you know, we're going to list this at 875. It is not on the market yet. That's one of the reasons we bring these things here first, is to give people who come to our multifamily meetups first shot at some of these listings. So this is in Westlake and just kind of south of Echo Park and south of Silver Lake. So in 90057. So if any of you are interested, feel free to reach out. Let me see. Yeah, that's it. I'll share my contact information. From here, we always like to do just a short section on needs, deals, and wants. So if anybody has a need, deal, or want that they're interested in, you know, please feel free to share now.
Yeah, go ahead and unmute yourself and let us know if you have something that you've been trying to find and you haven't quite been able to, or anything like that, please. I know, Jay, you just posted a listing you have coming up. That's a great thing to note. If you want to mention that, feel free.
Sure. It is a Spanish duplex. It's 100 years old. So it's a corner lot on Manning in the Cheviot Hills Rental Park area. They're both vacant. That's why the sellers are finally deciding to sell it. It's 4 successor trustees. Parents own the home for 60 plus years. They grew up in this property. It's in the heart of the zone, probably around $2,250,000 is the list price. They're up, you know, single level, upstairs, downstairs style duplex here in the West Side.
Awesome. Thank you, Jay. Anybody else? Anyone in the room here? Anything? Okay.
I have a property. This is Viviana from Coldwell Banker.
Hi.
Hi, I have a listing I just got signed. It's in Silver Lake. It's a duplex. Problem we're having with the tenant is she's kind of being resistant to cash for keys. The other tenants in it's a 3-bedroom, 2-bath house with a little small studio attached. It's a 1939 rent control. property. The owners owned it only as an investment property since 1990. He's 75 and wants to liquefy his assets. And I'm in a little bit of a panic because I don't know how to help him if this tenant's going to be difficult. I talked to 2 attorneys today and they were not very, they didn't give me much hope. So I was hoping that someone here could kind of give me some guidance and get us moving. It's a wonderful property in Silver Lake, right behind the Whole Foods, right on Glendale and Fletcher. And yeah, I'm a little bit of a pinch with it, just trying to do my best to kind of navigate it and encourage her. She's 3 months arrears in the rent. He's offering to forgive that debt, give her $20,000 and allow her to stay till June 30th. And still being
our
kinda-
attorney, we have our eviction attorney here who's willing to maybe like chime in for a second. Hold on, Viviana.
Yeah, great.
They probably can't see me.
It's okay. You can come over here wherever you
That's Hello, Viviana. If she's 3 months in arrears in the rent, why isn't anybody just evicting her?
Well, we were hoping to go the peaceful route, but it looks like that's where our next step is. So we were on the phone all day trying to find an attorney. Several of them wouldn't even take my call, and I've been waiting for calls back all day, but we're kind of at that precipice. She wouldn't even sign the disclosure about rent cash for keys. She was like, I'm not gonna until I see, and it's just a disclosure, it's just a notice. So I know that that's just indicative of problem we're gonna have ahead.
Yeah.
And he doesn't have a year. He can't wait a year. I don't know how long it's going to take. We've heard up to a year. So he's in a family predicament where he needs to liquefy his assets. He's going to have to pay up the nose in capital gains on this one. He doesn't want to do a 1031. He needs the money.
Okay, how much?
So I just wanna
How much money have you put in front of her?
Well, it's probably over 30,000, including the rent that's in arrears. But 20,000 in addition to the debt that she owes him.
All right. So you basically, the problem is that you've been sitting on this ability to leverage her without actually executing the leverage. So
Okay.
she's a special kind of tenant. We have there's a legal name for it. It's called crazy.
Yeah,
She's
crazy
crazy.
entitled.
She's insane. Okay, she's not going to
Yeah.
sign anything because she thinks that she's signing away her life. You could take her through every word of that document and she'll still believe that somewhere in there it says that she has to leave, give you all the money, and then give you all of her children as well.
Yeah.
No point. There's no point in trying to reason with her. What she will understand
right.
is that she's in an eviction, and now you've leveraged her to the point where if she goes through with this eviction and loses, and she probably doesn't have any good excuse for not paying the rent, if she goes through with the eviction and loses, she's going to be out, whether it's 3 months, 6 months, doesn't matter. She's going to be out at some point.
Yeah.
With
Yeah.
no money in her pocket.
I did tell her that initially. I said,
They
you can
don't
do cash for
believe
keys.
talk. They do
Yeah,
not
you're right.
believe talk. They also don't believe that you're going to give the money.
Right.
They just fundamentally, they have a fundamental distrust of lawyers, brokers, anybody who's coming around to try and cheat them, right? So you
Yeah.
need to put them in a
Yeah.
position where it's not really subject to belief anymore. Here's an eviction notice. Here's
here's
actual
what's happening.
eviction complaint. Here's something where you
Right.
have to respond to it, or else we're just going to get you out for free, and all the better for us. Then she's going to have to
Yeah,
go to
yeah.
one of the many free lawyers she'll get. That's not a horrible thing because we already have money on the table, right? $30,000
Right,
plus waiver is a great deal, right?
Yeah. Right.
So that lawyer is going to become our friend and help us push
Right.
through a settlement that didn't exist when the UD complaint didn't exist. But if you don't have it on file in her face and forcing her to respond, you have no leverage.
Right.
Why would
Yeah.
you take
She's
why would
dragging
you
her
take your
feet. You're
deal?
right. That's right. So when can we
Thank
get
you,
you a
Viviana.
retainer and get
We'll get you his
when can
contact
we get this
info.
happening? Love it. Love it. Thank you so much.
Yeah, so glad you're here. Perfect timing. Okay,
Awesome.
so I just wanted to bring up a couple of things before we get in back to Niv. So I know that it's been in the news a lot lately, the NAR commission, buyer broker settlement commission that's out there. And there's a lot of confusion and a lot of people don't know exactly what's going on or how it's going to play out or how it's going to change the real estate industry. I am putting on a seminar to explain in detail what that means, what that looks like, how it's going to affect realtors, how it's going to affect buyers, how it's going to affect sellers, what my personal opinion is as far as what the best way to handle this would be. And we'll be discussing that on April 10th at 11 a.m. So if you want to save that date, it'll be the same RSVP link, thecollectiveeducation.com. That'll probably be up and live by the end of this evening. So maybe check on it tomorrow. But on April 10th at 11 a.m., I'm going to have a great presentation to kind of explain all of that to you. And of course, if you have questions and answers, let me know. If you happen to be a realtor, I'm going to be doing a second session that's on what are going to be the actual practices that happen. What are agents talking about now? What are they going to be doing step by step to get through this time? So it'll be just for realtors, but it's going to be a session to walk through and to talk and discuss what are the actual best practices of moving forward after July when all of this takes place. So please stay tuned for all of that. Lastly, I just wanted to say again, thank you guys so much for being here. If you are a realtor, we have a great office. We're a boutique company. There's no corporate people telling us what to do. It's just me. The realtors are our clients. We have an amazing commission split with a cap. Once you contribute $30,000 to company dollar, you get a 96% commission split. There's no monthly fees, low E&O insurance, lots of support, coaching. If you need marketing, we get all that to you design-wise, anything that you need. I would love to talk to you. I am looking for a few more agents to keep growing our office. So please reach out anytime. You are all welcome because you're learning based. And that's one of the number one things that I look for in an agent is if you're learning based. So if you're on this call, you're one of my favorites. All right, Niv, let's come on back to your presentation and take it over. You can stand wherever you want. I'm gonna, let's see, get this view back to our gallery. All right. Just stand near the mic. It'll be just a little clearer for everyone on Zoom to hear. You can come here if you want to look at the camera.
All right. Cool. Hello. Everyone hear me? Good. All right. Fantastic. Hello, everybody in the room. All right. Like they said, I'm Niv Davidovich. Davidovich Stein Law Group is a full service real estate, landlord, tenant, and construction law firm. That's where we work. And we basically are a one-stop shop for owners, developers, property managers, anybody who's in that space. We handle evictions, all other kinds of civil litigation. So real estate litigation, construction litigation, landlord tenant, habitability claims, bed bugs, ADA, mold, whatever it is they're complaining about the next day. And as well as transactional, we do transactional stuff in all of those fields as well, whether it's leases, purchase agreements. And we also, a lot of what we do is just consulting, answering questions for people. We get lots of questions from brokers and agents just like you all. And it's obviously not a very good idea for you guys to give legal advice. It's a big no-no. So we're happy to be your support when your clients are asking the very relevant and very difficult questions, whether they're buying single-family homes or multifamily, and whether they've been in the business for a day or 37 years. Everyone seems to have the exact same questions because the politicians think it's fun to change the rules every other day. So yeah, that actually happened to us one day, 2 weeks ago. We won a motion and the tenants didn't like it. So the issue was covered in the news. So they went to the city attorney of Los Angeles and got them to change the law. And then the city of Los Angeles voted on it 6 days after that. And so then they filed a motion to have it reheard. Then they weren't counting on the fact that judges don't like it when you do that. You try and cheat. So the judge said, okay, thank you for changing the law. Motion still denied. So it is very important to understand the rules, and literally they can change on you in the middle of your eviction. So I wanted to tell you guys first a little bit about some of the new laws that have changed statewide. So this is going to apply no matter where you are, whether you are in the city of West Hollywood or Los Angeles or up north or in San Diego or in San Bernardino. The next stuff I'm going to tell you applies statewide. Okay. So first is the changes to AB 1482. If you don't know what AB 1482 is, you know, it says, what I was going to say was, oh yes, ignorance is bliss. If you don't know what that is. But 4 years ago, the state passed statewide eviction and rent control. As compared to other kinds of rent control and eviction control, it wasn't as bad. And one of the features it had, and still has, but they've now changed, is what's called a substantial renovation eviction. So that basically means that even though you couldn't just send someone a 60-day notice like you could before and just say, you got to go because you're month to month, you could send them a 60-day notice if you wanted to do a substantial renovation. Well, what's that? It's defined as a substantial modification, repairs to a system, one of the major systems, a structural, mechanical, that means HVAC, basically heating and air conditioning, plumbing or electrical. It has to be something where it would take 30 days to do, 30 consecutive days to do. And it has to be the kind of work that the tenant could not be in the unit for that 30 days, right? So that's what means substantial. So before, you would just issue them the 60-day notice. You had to intend to do the work. But if you didn't do it afterwards, or if you changed your mind or ran out of money, there really wasn't anything the tenant could do, right? So you could just make stuff up really if you wanted to. Well, they kind of closed that loophole. Now, number one, you have to have the permits in hand when you serve the tenant, right? So they want to know that you've actually gone to the city and pulled permits. You're really going to be doing this work. You have to give that with the 60-day notice. You also have to really do the work. And if you don't do all the work that you said you were going to do, the tenant can come back and say, I want to come back. And you have to give them the unit back at the old rent they were paying, right? So there are consequences for not doing the work. So you can't play games anymore. If you want to do a substantial renovation, you really got to do it, right? That's the major change that happened to 1482. There's also some changes to the verbiage, but that really more issues for a lawyer. The practical issues is what I just said. The next thing is AB 12. AB 12 basically says that from now on, if you're in the leasing game, you are not allowed to charge a security deposit of more than 1 month. There are virtually no exceptions to that. There may be some mom and pop stuff, but for most people, it's 1 month. And it doesn't matter if this person has poor credit, or if it's furnished, or if there's a dog, or if they're bringing in 17 crocodiles with them. It really is not relevant. You can charge 1 month's worth of security deposit. There's no pet deposit on top of that. There's no baby deposit. There's no other kind of deposit. 1 month. That's it. From July 1st going forward. So if you do your lease and you get everything signed and they pay their first months on June 30th, 2 months or 3 months as the law provided before, 2 months for not furnished, 3 months for furnished, go to town until June 30th. On July 1st, party's over. 1 month it is. All right. And the next big change is what happens with Section 8 applicants. Okay. So for those of you who are in the multifamily space, you know that a few years ago, they added source of income discrimination as one of the protected classes when it comes to housing discrimination. They called it source of income because people can get vouchers from other places, and there are other sources of vouchers, but the vast majority of people who are coming with vouchers are Section 8 people, right? If for some reason you're not familiar with Section 8, Section 8 is basically a federal program that provides rental payment assistance to people who are low income, right? And so they have to apply. Some people have some, I don't know, like magic ticket where they come in, they come in on LAX from a foreign country. By the time they get to their apartment, they're on Section 8. Okay. And some people have to wait for 10 years. I don't really understand how the line works, but once you have your Section 8 voucher, you come to a landlord and it'll say, I have a voucher for, let's say, $2,000. The unit's $2,500, and Section 8 says I pay $500, right? Now, it used to be that you could just say, I don't do Section 8. Why? Because Section 8's a big pain in the ass, right? You can't raise the rent without getting your Section 8 advisor's permission. So even though, for example, let's say you have a building that's not rent control, right? And the rent increase is 8.8%. That's what's allowed under AB 1482 for a unit that's not otherwise locally rent controlled, right? And you come to your Section 8 advisor, you say, I want to raise it by 8.8. That's the amount I'm allowed to raise it, right? They'll look at their comps and they'll say, no, you can raise it by 2%. You'll say, that's insane. The max limit is 8.8, and you have your own numbers. If you're an experienced real estate person and say everyone else is doing, at least 6 on average, but most people are really maxing it out at 8.8. How could you say it's 2? Show me your comps. And they'll say, no, our comps are proprietary. We can't show you that. Right? I've seen this. I've seen this exchange between the Section 8 person and a landlord. So it's difficult to deal with Section 8. On the flip side, Section 8 pays their rent like clockwork. It's money that is coming from the federal government administered through the local housing authority. The housing authority is just a pass-through. You're really getting into a contract with the feds. And since the feds have all of our money, they have enough to pay you, right? So there's a good and a bad to it. Anyway, a lot of people said, I don't care about that. I'm not doing Section 8. Well, they said you're not allowed to say that anymore. Nowadays, because they added source of income as a class, that's discrimination, right? Saying you don't do Section 8 is the same thing as telling someone, I don't rent to Jewish people. It's the exact same thing, right? That's how you need to understand it.
And they're testing.
They send out
they're calling
testers.
people.
Right. So disability group. Now, well, yeah, mostly it's disability groups, but yeah, I guess some people. They're Section 8 testers. Okay. So testers are people who are basically spies, right? They're not government employees. They just do this on their own and it's completely legal. They will call you and pretend to be a tenant, right? And say, I want to rent unit 101. How much? Blah, blah, blah. And then they'll have their buddy call and say the exact same thing, except for they'll say, I'm on Section 8, to see if you give the Section 8 person a different answer. And if you do, they'll bring a discrimination claim against you and they'll make you pay money and they'll record. I mean, well, they can't really record all of it. That's not legal, but they'll just declare that all of this was said, right? It's dangerous. So you're never allowed to say, I don't take Section 8. That's a big no-no. Don't ever say that.
Or even treat them differently. So
correct.
If you were like, you show one of them a property and you don't show the other one, you don't get back. You're like, oh, I'm booked until next week, and then you don't call them.
Right.
Anything like that.
Correct. You have to treat everybody the same. It does not mean that you have to accept every Section 8 person who makes an application. That's not what it means. Okay. Now, a lot of people were basically saying, all right, fine, Section 8 person, we'll take your application. Let's see your credit. Well, Section 8 people are low income, and because they're low income, a lot of the times they don't have very good credit. Making a decision about whether you rent to someone based on credit is 100% perfectly legal. You are allowed to do that. That's what credit reports are for, is to decide, do I want to do business with this person? Are they likely to pay the rent in full and on time? Well, the government didn't like that either. So they basically now said that if you are taking an application from a Section 8 person, you're not allowed to consider their credit report or their credit history. That's the actual term that's used, undefined, of course. Credit history in analyzing that application, unless you give them an alternative opportunity to provide verifiable proof of legal income sufficient to pay their portion of the rent. So you have to have some sort of rental criteria that you use. A lot of people have 2.5 times rent. In other words, your income has to be 2.5 times rent. A lot of people do 3 times rent. If you want to be really conservative, you go 3.5 times rent. One way or another, you have some sort of rental criteria that is consistent among everybody. So let's say you have a unit that's, like I said, $2,500, right? And the person comes and says, no problem, I can afford $500 and I have a voucher for $2,000, right? You cannot just look at their credit and say, well, you also have a 400 credit score. You don't get to live here. You have to basically say, all right, can we see your source of income? Can we see your verifiable proof of income? They can show you a W-2, they can show you a 1099. A bank statement doesn't cut it because they could be selling crack and then just putting the cash in the bank account, which is incredibly stupid, but it's also a possibility. So that's not verifiable. That's not a verifiable means of legal income. So they have to show you legal income. And all they have to do is show you, in my example, that they make $1,500 a month, right? In my example, how anyone survives by having another $1,000 a month living anywhere in this county, I have absolutely no idea. But that's what they have to show you. If they do show you that, again, it does not mean you have to accept them. There are lots of other reasons you can say no to someone, right? So I don't care if it's the Section 8 guy. I don't care if it's a regular person who come in and they have perfect income, perfect credit, and they've also sued every landlord that they've ever lived at, right, or with. That's an economic risk. That's a risky person. You could say no to that person because they're an economic risk. If that person also has cleaned up their life and they have great credit, 800 credit score, making 150 grand a year, very lovely, and also is a serial killer, convicted serial killer, that'd be a big no. Don't rent to serial killers. And you are allowed to say no. A lot of people have that question. Oh, I thought they had a law that says I can't take into account the criminal background anymore. Nonsense. That law has never passed. They've talked about it. They've advertised it. They've tried to make you think that it passed. It has never passed. You not only can say no to people with a criminal background, you have a duty to say no to people with a criminal background, because you as a landlord have a duty to protect all the other tenants in the building, not to mention their guests, not to mention your vendors, not to mention your employees, and not to mention, last but not least, you. If you go to your building, you don't want a dangerous person living in one of the units. And there are a lot of crazy people out there who did a lot of crazy stuff in their background. And if they've cleaned up their life, that's very admirable, but you shouldn't be the litmus test to see if it's stuck, right? Neither should your tenants. So like I said, just because a Section 8 person is coming in and giving you an application, it doesn't mean you have to say yes.
So, Niv, just sorry to interrupt, but a question I do get from owners of properties that are trying to rent out is, oh, we're not allowed to run credit anymore. Is that true?
It's not true.
And I always tell them it's not true, but where did that come from? I think LA City Council was debating it, and then it just never.
No, you are absolutely allowed to run credit. You can even run the Section 8 person's credit, right? You just can't use it as an excuse for saying no to him, right? So the important point is, I have a completely different view on this than a lot of other attorneys. I know there are attorneys here, but what I'm about to say is very controversial, but I'm going to say it anyway because I think it's good advice. Okay. The way it works is this: if you deny someone because of their credit, you have to tell them that. You absolutely have to tell them that. But you can also deny someone for more than one reason. They might have, let's say, bad credit and, like I said, serial killer, right? They might have bad credit and also very bad litigation history. Maybe they've gotten into like 15 lawsuits. None of them turn into judgments, but you see they're a very litigious person, right? That you don't want to do business with. And that's an economic question. That's an economic decision. You are allowed to make decisions based on economic principles. You're just not allowed to discriminate arbitrarily. Now, do you know who knows which reason you're picking and which one is the foremost for your decision? Only you know that. It's all in your head. As soon as you put it down in writing and you tell the tenant and his lawyers can be very creative and turn anything you say into a discriminatory reason. I will give you an example. Okay, and this is what led to my innovation. A guy called and said, I had someone who applied during COVID. He had no job. He had almost no credit. Now, I didn't say bad credit. I said he had almost no credit. He was kind of off the grid, right? It was just weird credit. But he had no job, no income, no disability payments, no SSI, nothing. He had one form of payment, a COVID voucher. COVID vouchers expire. They're not like Section 8. They're not forever. They're for like a year. And he applied and said, this is how I plan to pay the rent. And the landlord said, well, when the COVID voucher's done, you're just not going to be able to pay the rent. So I can't take you. Plus your credit is weird, right? He went to LAFLA, that's the Legal Aid Foundation, who also went to the city of Santa Monica. They're buddies. And they wrote him a letter and said, you're discriminating based on source of income. It doesn't matter that it's a COVID voucher. It doesn't matter that it expires. You're still discriminating because that's his source of income. And if it runs out one day, that's your problem, not his problem. Today, he has money. And today, that's his source of income. You can't say no to him because of that. And you can't say no to him because of the stuff on his credit, because those are traditional notions of credit. I don't know what a traditional or a progressive notion of credit is. I just know there's good credit, bad credit, no credit. That's it. That's all they taught me. Okay. But no, they're trying to twist it into something, and you can twist anything you want into something discriminatory, literally. So if you give them something, they'll turn it into something else. But they're not alchemists. They cannot turn nothing into something. So you simply ghost people. You don't want to say yes to someone, don't call them back. They call you, right? You basically say, oh, I'm sorry, the person who makes that decision is still looking at your application. 1 month later, still looking at your application. 3 months later, still looking at your application. They'll say, this is insane. You guys are the worst managers in the world. How can you be looking at an application for 3 months? You say, you're right. We're stupid. We suck. We're very inefficient. But there is no law saying that you have to be efficient, right? Look at the government. They do it all the time. If they can, we can. Once you tell them what you're thinking, once you put it down in writing, they can use it. But if you just tell them nothing, what are they going to do? They're going to come to the lawyer and say they're discriminating against me. Okay, based on what? Name it. Doesn't matter. Okay, did they text you something? No. Did they say something? No. Did they write you something? No. Did you get a reasons for them? No. What's the lawyer going to do? He has no evidence whatsoever. He would have to somehow figure out the makeup of all of the tenants in the building and show that you're discriminating against this one person based on some protected class that he's in that everyone else in the building isn't. It's impossible. It's impossible. No lawyer is going to take that on, right? And the city's not going to take it on because you have nothing. And even if the city calls you, say, sorry, like we're still looking at his application. If at some point you have to say no, you say, okay, yeah, we said no over the phone. He says, why? You say 3 magic words. I don't know. I don't know. What do you mean you don't know? You have to know. He's like, I don't make these decisions. Even if you're the decision maker, say, I don't make these decisions. I have a partner, investor, executive, managing member, king, duke, baron. I don't care. Make up whatever you want. Okay. There's somebody else who makes these decisions, who lives behind some magic cloak, right? A curtain. And that person said no. I don't know why he said no, but he told me to say no. I fought for you. I like you. But he said no, and he's the one who has the 51% voting, right?
So I think that's a really good point. I know there's a lot of realtors on the call. If a tenant asks you, why was I denied? You just say, I don't know. I don't know. The seller says they didn't accept your application. It was denied. That's it.
There is a question on the chat. What if they find out you rented it to someone else during the time you were saying you were still looking at their application? Do they have a case? I think that's actually better for you if you did rent it to somebody else. But what do you say, Niv?
You just do exactly what the government does. The right hand doesn't know what the left hand is doing. We were looking at your application, and then someone in a different department took someone else while we were looking at your application. I'm sorry. They already signed the lease. Next time. The government pulls this nonsense on us all the time. You send them documents, right? They say, we're looking at your permits or we're looking at your plans. 2 months later, oh, we lost your plans 2 months ago. Can you resubmit them? Like, okay, what about the 2 months I lost? Sorry, not our problem, government workers. right? They do it all the time. So as long as you're staying within the confines of the law, you can do it too, right? Be inefficient, be lazy, be smart.
You
Yeah.
talked about litigation. So when I do like a regular criminal background check, will any of that come up?
You're not going to get the litigation history. You can go to lacourt.org, but that'll only tell you their LA history. LexisNexis, Westlaw might provide you some more. It's really more of a specialized search, right? But there's a lot of people who get.
It's a good question.
Yeah, a lot of people get duped into this kind of stuff, and they look at a person's criminal background search. Okay, fine, he's never been arrested. La-di-da, that doesn't make them a good person. It doesn't mean that they haven't filed 15 HAB cases against the last 15 landlords they've been dealing with, right? There's a lot of tenants who are either grifters, where they're actual real con men and con women who will give you, I don't know how they're doing fake credit reports. This is a magic trick I still don't understand, okay? But they're doing fake credit reports, fake IDs, fake bank statements. That one's really easy. I can do that one. But they're giving you all this fake stuff, and then maybe they'll pay you for the first month, but a lot of the time that cashier's check also comes back NSF and is forged or is fraudulent, and they'll just live there for free until you evict them, right? And then they'll pull that grift on the next guy, and they'll live for free their entire lives, right? And so it's hard to check on those kinds of people, but you have to do a little bit more of a deep dive to see if you're dealing with a con man or with a person who makes their living doing HAB cases. You know, they go from landlord to landlord filing habitability cases, right? And you can make a lot of money like that, right? So the only way to check that is to do litigation searches, which requires a little bit more, can't do it on the $40 background search, unfortunately. Those are pretty much the three big issues. And now that we've seems to have gotten into the Q&As, I'd love to just open it up to Q&As. So you mind if I take this?
Yeah,
Thanks.
One question from Jay. Oh yeah, go ahead and scroll.
The process on notice to a tenant when listing a property that rented based on 2024 laws. So Jay, I don't understand the question.
Sorry, so I have listed a property. It is currently tenant occupied. They were on a 1-year lease and is now on a month-to-month, which I guess doesn't matter now because we can't evict anyone, or if they are a month-to-month, it still is meaningless, correct? And that at one point when they went month-to-month, the owner would say, hey, I'm going to sell. I'm no longer renting this property and we're done. But I guess what I'm understanding is now if they move on to a month-to-month, it's a single family home, the owner wants to sell.
Where is it?
It's in Los Angeles.
City of LA?
City of LA, County of LA.
Okay. Yeah, so basically what happened was, let me just explain to everyone, Jay, what occurred here and what you're talking about. In January of 2023, the city of LA, in its infinite wisdom, decided to pass a just cause eviction ordinance. It basically took most of the elements of AB 1482 with some minor changes and then grafted it as a requirement onto all of the housing stock in LA, including single family homes, including condos, and including units that are even newer than 15 years old. This is all stuff that would have been exempt from AB 1482, which is that California rent and eviction control we talked about a few minutes ago. But they basically took it all and said, no, all of that now applies. Perfectly legal for the city to do, unfortunately, right? And by the way, in Santa Monica and West Hollywood, they've actually had that for a long time. Every single unit, whether it's single family home, condo, brand new apartment building, doesn't matter. And the city of Santa Monica and city of West Hollywood have been under eviction control for years, right? And a lot of people just kind of didn't realize it. Now the same thing is in city of LA, right? So that basically means, let's say you have your single family home, right? The person's been there for a year. You can't just give them a 60-day notice and say, okay, I want it back now. You used to be able to do that. It was like that 60-day notice. They had no right to stay. They signed a 1-year lease. They had no expectation to stay longer than a year.
Right.
Game is
Now
over.
what?
Now basically, so you're saying you have a house, a single family home with a tenant in there. They're currently month to month, and you want to list this property for sale.
Correct. But we have to sell it with the tenant in it, correct? We
Correct.
can no, okay.
There's one thing you can do, and it's a tactic that is sort of unique to single family homes. One of the reasons that you can give a notice to quit is to take a property off the rental market. Now, a lot of the times, if you are doing an apartment building, that's kind of pointless. You're probably going to sell it to someone who wants to keep it on the rental market. But if you're selling a single family home, you may very well be selling it to someone who wants to live in it and never wants to rent it out. So even under the JCO, if you want to just take it permanently off the rental market, you can go ahead and give your 60-day notice. Depending on who your owner is, they're going to have to pay some relocation fee. If they're like a real mom and pop owner and really all they own is this single family home, right? They
Single
might
mom, single, yeah, this is.
no. They don't have to be single. They could be married.
No, I know. I mean, but it really is a mom and pop. It was a first home she
Right.
bought, single mom. She's selling it, first time selling a
She's-
property.
She can take it off the rental market, give them a 60-day notice, and pay them just the 1 month's rent. Or basically just waive the rent for the last month. So if she wants to get rid of them, she can do it that way. Now you're going to have to disclose. I would recommend in your MLS, this property was taken off the rental market pursuant to the JCO, right? What does permanently mean? Nobody knows. They didn't define it. It just says permanently, right? And they said, you guys figure out what that means, right? So we really don't know. But again, if you're the broker and she's the seller, as long as you're willing to do that, it's not your problem. All you have to do is disclose it. And now it's the buyer's problem to figure it out.
But if it's sold with the tenant in it,
If it's sold with the tenant in it, then what you could do is and the buyer wants to live in it. The buyer now has a unique opportunity. They can do a landlord move in, and they don't have to take it off the rental market. They just have to live in it for 2 years, right? So they can give 60-day notice, pay their relocation fee, likely unless they're a professional in the real estate business, they'll also only pay the 1 month's rent, right? Or basically waive the last month's rent. There's a whole procedure to it. So it's going to, it has a legal cost to it, but we help out with that and we process the whole thing. And then your owner can get in as long as he or she wants to live there for 2 years. They're good. After 2 years, they can actually put it back on the rental market.
so do you foresee, based upon, obviously all of this is kind of new from 2023, any issues that would block a person who is buying it for owner occupancy, because it is a single family residence?
Yeah.
The tenant can be difficult and block them from being able to move into it, and that's the greater issue.
They just stay. Anytime you give a 60-day notice, 3-day notice, 10, it doesn't matter what notice. All that is the beginning of the eviction, right? The tenant can also just violate that notice and stay. And then you're going to have to do an unlawful detainer. That's the fancy name for an eviction, right? They might, in the case of the 60-day notice issue, the no-fault evictions, they might be threatening their ability to get some or all of their relocation. And they may end up with a judgment on their record if you go all the way. But most of the time when we do the 60-day notices and they want to stay for a little while, we make some kind of a deal in the eviction procedure. Maybe a little bit more money, maybe some rent waiver, but it's better than going to trial.
True. And what if they have kids? Is there a different rule for families?
Nope. Only in Santa Monica.
Okay. I had to deal with that in Santa Monica. That's why I'm curious.
In Santa Monica, they have a special rule that says no matter what you do otherwise, you can't evict anybody that's got minors who go to a school in Santa Monica or a teacher who works in Santa Monica during the school year.
Correct. We dealt with that.
Stupid rule that pretty much takes evictions off the map for a lot of different situations for like 9 months out of the year. But that is a dumb rule that Santa Monica has.
So
Well-
Jay, that's a really good question. And this is super, super common that as realtors, what we deal with is if I'm looking for a property to buy, I know that my client wants to move into one of the units, whether it's a triplex or a single family home. They want to move in, they want it vacant before the property closes escrow. The only way to do that, you're saying, is for the current owner to say that it's off the market permanently as a rental. There's a process. They call you. Approximately, like, what's the timeline to get that started and cost for something like that?
Correct. That was my next question.
So the fee that we charge to basically do the entire pre-UD process in the city of LA is $2,000 flat. That's the attorney's fees. There's also a fee that you have to pay to the city. And there's also potential relocation fees that you have to pay to the tenant. Again, it all depends on who the landlord is. If it's a really mom and pop situation, they'll probably only have to pay 1 month's rent. If they're a mom and pop landlord, they might qualify for a different discount. If they happen to be some real estate person with a bunch of units in their name, but they're also just doing this single family home, they're going to have to pay the regular amount that everyone else pays, which is a range of relocation from $10,000 to $25,000, depending on how long the tenant's been there, how much money they make, and who's living in there. This is the one place where a child will make a difference, because you can get the higher amounts, right? Either 18K or 20 or a little over 24K if you have a disabled person, a person who's 62 years of age or older, or a minor living in the unit. It doesn't have to be everybody. It could just be one person. I don't care if you have 18 people living in the unit who are all 25-year-old single bodybuilders. If there's one kid, that's it. That's a qualified unit, right?
So sorry. And so I have two more questions. How long does that process take the entire pre-UD process, 2,000 flat
So
fee?
for us, so that's not the UD process. That's the pre-UD process. That's you have to
Okay.
fill it. You have to draft and file the declaration with the 60-day notice, file it with the city, then serve it on the tenant. If there's relocation monies to be paid, it has to be deposited with an escrow or an attorney-client trust account. We provide that service as part of the flat fee. It's much better to have the money with your attorney than it is with an escrow, because if something happens and you have to cancel the whole thing, I have to give you the money back. The escrow doesn't, right? And trying to get the money out of the escrow is damn near impossible, right? So we handle that entire process. And then as long as they are complying with the 60-day notice, they'll come to our office. We will cut them the check. They also have the opportunity to get advances from the relocation for first month security deposit and moving expenses. They have to provide you proof of that. We do that whole thing. If they ask for money in advance, that's part of the flat fee. If they
Okay.
don't leave, then you have to file a UD. That's a whole different situation. We have a UD rate sheet. We bill on that rate sheet. Some of the things are flat fee, but everything else that we do in the UD is hourly at $3.25 an hour. Those are our UD rates. Those are not our regular rates for everything else that we do.
And then if we are going to list with the tenant in it, and I swear it's my last question, then I just have to give them a notice of entry when I'm going to show, but that's about it, correct?
Pretty much.
Okay.
Yeah.
I just wanted to affirm what I thought I would have to do to sell it with the tenant in it. And thank you for verifying all of that. I appreciate it.
How early would you recommend a seller to start the process with you? Like, do they have to have a listing agreement in place?
No.
Or
do it for any, you can take it off the rental market without even wanting to sell it. You could just take it off the rental market. You say, I don't want to be a landlord anymore. I'm opposed to the concept of being a landlord because the rules are so stupid, but I don't want to sell it. I want to turn this house into my own personal arcade. I'm going to fill it up with pinball machines. Take it off the rental market, go to town.
So then what happens if you put it back on the rental market?
Well, then we get into the definition of the word permanently, right?
And if that former tenant actually knows about it.
A lot of the times they'll follow up. If they're litigious, they'll follow up. If you do it like 2, 3, 4 years later, they'll probably forget about it. Yeah. Now, Sandra had an interesting question, which is a bit of a trick question. It says, is a 2019 ADU exempt from AB 1482 in the city of Los Angeles? And the answer is, it doesn't matter, because Any property in the city of Los Angeles is going to be subject to the JCO. So if it's not subject to 1482, even if it was exempt, it would just fall under the JCO anyway. And the JCO includes everything that 1482 has, plus some more. So let's
I have a question. if I may.
Okay.
I have a situation that is somewhat similar to what Jay was talking about. I am about to list 2 single-family homes in the city of Glendale.
On the same lot?
No, they're their own
Separate
separate
parcels?
parcel. So they are definitely single-family homes, each their own parcel.
Okay.
They are both tenant occupied, and the current owner had them sign leases when they moved in back in 2020 that had an automatic renewal for the same period every year,
Unless someone canceled.
unless someone canceled. Exactly.
Okay. Did he
Nobody's
ever
canceled.
cancel?
Nope, nobody's canceled. So their leases then would be in effect until this October.
Okay.
Now, since we are in the city of Glendale under LA County rules rather than LA City rules,
Nope. You're not under the LA County rules.
we're not.
No.
We're only under the Glendale rules.
Correct. Let me explain this issue. I have to explain this every single day. Okay. This is the way it works. LA County is like this big circle right here, right? Extra large pizza, right? And inside the extra large pizza is you have your little circles. There are 88 little circles inside of LA County. LA County is about 450 square miles big. It's really big. Okay. Inside there are 88 chartered municipal cities. The biggest one happens to be the city of Los Angeles. But the city of Los Angeles is just one of those 88 cities. Each of those cities has its own laws and rules. The space between the cities is called the unincorporated Los Angeles County, right? And it's exactly what it sounds like. It's places that are not within the city limits of any of those cities. You are only under the Los Angeles County rent stabilization ordinance and most other Los Angeles County laws if you are in those unincorporated areas. If you are inside one of the city areas, any incorporated city, you are subject to that city's rent and eviction control laws. If your city, like the city of Glendale, doesn't have any real rent or eviction control laws, Glendale has kind of like a pseudo one that makes you pay relocation if you give a certain rent increase, but it doesn't actually have a bona fide rent and eviction control law like Santa Monica, West Hollywood, and LA, right? Then you're just subject to the state law, but the county doesn't come into effect. Very, very important thing to remember, right? Now, if you are listing, by the way, your city of Glendale or any other kinds of properties, do not go by the mailing address. Big mistake. The mailing address is where the United States Postal Service thinks your property is. Their opinion is irrelevant. In order to find what city your property is actually in, you can go to lavote.org and you can look at the precinct maps. Type in your address and it will tell you every single kind of district that your property is in. The Senate district, the congressional district, the state assembly, the whole thing. The 6th line will tell you what city it's in. If it says city of something, you're good. That's the city that it's really in. If it doesn't say that, it'll say unincorporated name of some neighborhood, unincorporated East Glendora, right? That means it's the unincorporated part of LA County. You are now subject to the unincorporated, to the LA County rent control laws, completely different than 1482. So, Craig, in your example, if you have the 1482 exemption notice in the lease, right? Then your properties are exempt from 1482. City of Glendale has no eviction controls. It has no JCO. So you can just give them a 60-day notice prior to the October expiration and you're done.
Okay, that's kind of what I was thinking. So I'm relieved to hear that. These
But
properties.
make sure they got that exemption.
Yes.
Craig, do you know where that is? It's on a car form. It's a box you have to check.
Yeah, on
that
the car
talks-
form, I'm familiar with.
Okay, so if you check that box, then you're okay. If you didn't check the box, then wait till October. Yeah.
Okay, perfect. Thank you.
Well, no. If you didn't check the box, if you didn't give them an exemption, it's a little bit more complicated than that. So what happens is if you have a single family home, you're not automatically exempt from 1482. You have to meet two conditions. One, your property cannot be owned by a corporation, an LLC that has a member that's a corporation, or a real estate investment trust, also known as a REIT. I get this question a lot too. What's a REIT? Right? A REIT is not when John and Judy Smith own the property in their own personal family trust. That's not a real estate investment trust. A REIT is a publicly traded company that owns 30,000 units, and you can buy shares of it on the NASDAQ and NYSE, right? So if you're not sure if your property is owned by a REIT, it's not. Okay? So as long as you've met that ownership exemption or that condition. The second is you have to have given them notice that the property is exempt from 1482. There's very specific language you have to copy and paste and give it to them. Okay. Now, in your example, Craig, usually what we would do is if we have a property was on a 1-year lease, went month to month, and they didn't give the notice, we would give a 30-day notice of change of terms and say this provision is now added to your lease, right? And the law seems to say that you're allowed to do that even if you didn't do it within the timelines provided in the code, right? That's what we would do. But we can only do that because they're month to month. In your case, they're not month to month. They're essentially year to year, right? We can't give them a 30-day notice of change of terms in the middle of one of their 1-year terms. So if you didn't give the notice, if that's not somewhere in their lease, you're going to have to wait essentially until the 1 year is up, then give your 30-day notice, wait for that to expire, then give your 60-day notices. Okay. But you have to tell them 60 days before the expiration that you're not going to renew. Okay. So
It's like a game of Twister. I swear to God.
Oh, it's much harder than Twister. It is much harder than Twister. Oh,
That helps
exactly.
immensely. Thank you.
Okay. Oh, Jay also says, do they have to give them back the security deposit, or once it's collected and rent starts before July 1st, is it good? No. So you're talking about AB 12. If you collected 2 or 3 months security deposit on June 30th, you do not have to give it back on July 1st. Okay. Wow, definitely interested. Does Niv work with Charlie Stein? Yeah, Charlie Stein is the Stein in Davidovich Stein.
I'm gonna give you her email later. She wants you to contact. She had to hop off early.
Okay. Any other questions? Let's see.
Down.
Down? Okay. Okay. If a buyer purchases, okay, wait. No, Sandra asks again, for the above ADU, can I increase rent? Is it limited to 8.8%? That's interesting. All right. So the ADU has a COO that is in 2019. Technically speaking, it is probably exempt from 1482. So you can give, it's exempt from the rent control provisions of 1482. So you can actually give a 10% increase. People ask, why am I saying 10%? Because it's a fun little thing that the state of California has called an anti-price gouging statute. And this is an artificial way to keep rent control at least at 10% for as long as you want to have it. All you have to do is pass a local emergency in your area. In Los Angeles, we've been under a local emergency for about 6 years straight, right? It was either fires, and then when the fires came out, it was the floods, and then the floods went out, and then they had COVID. That was for 4 years, and COVID was going to run out. So they're like, we got to find a new emergency. They're like, I know, homelessness. Cool. That's going to be around forever. Right? So they passed homelessness emergency, right? And we've been in that since before COVID, right? Since December since December 22, we've been in a homelessness emergency. Basically, the mayor got into office, had a cup of coffee, and passed the homelessness emergency. She did it like that morning, right? As long as you have a homelessness or any emergency in your locality, it triggers the price gouging statute, and it basically says you cannot raise the rent more than 10%. Technically speaking, it even says you can't raise it from person to person. Like, in other words, from tenant to tenant. Does anybody follow this law? Hell no. At least not the second part, right? That's the abolition of vacancy decontrol. Nobody follows this, and no one gets caught, because how do you know what the last guy who already lives in Flagstaff, Arizona, or is already on a cruise with his girlfriend for 6 months? How do you know how much rent that guy was paying? You don't, and it's impossible to find out, right? So nobody really follows that part. In terms of the 10%, a lot of people don't know that part. But if they go to a landlord tenant attorney that knows what they're doing, you will get caught. If you want to try it out and give a more than 10% notice, be my guest. The worst thing they'll say is you're doing that illegal. You say, oops, I didn't know. See, I don't know. It comes in handy very often, right? So you say, I don't know, and you give them a regular one. Just remember, if you give an increase of more than 10%, it is not a 30-day notice. It is a 90-day notice. A lot of people get confused. What are you talking about? A 60-day notice. These are two different things. If you want to change a month-to-month lease and change the terms, that's a 30-day notice. If you were somehow able to, and you were in some sort of unique, weird position where you could actually terminate a lease because they've been there less than 12 months, you could do that on a 30-day notice. But if you want to terminate a lease where the person's been there for longer than a year, that's a 60-day notice. That's all for terminations and amendments to the lease. If you want to do price increases, rent increases, that's different. Less than 10% or less, 30 days. More than 10%, 90 days. Clear? Good.
Two questions. Stacy? Or actually, was there one about Stacy?
Right. So okay. If a buyer purchases an RSO property, 4 units, and inherits a tenant without a lease from the seller or the tenant, how are terms, rules, and regulations determined? Bad news for you, they're not. So when you inherit a tenant without a lease, it's very problematic. If they start breaking what would be traditional rules of a lease, we can't really do anything about it. We can't give them a notice to cure or quit, because what are we asking them to cure? Right? So they can technically sublease the unit. There is nothing illegal about assigning or subleasing a unit. The reason you're not allowed to do it is because it says so in the lease, but it's inherently perfectly legal. So they can assign, they can sublease, they can do anything they want short of the things that will subject them to an eviction under 1161-4 of the Code of Civil Procedure. Sorry to get dorky with you, but that's the fun one, because you don't have to give them a cure, or you don't have to give them a cure option. You just tell them to leave, but the options are limited. They have to be a nuisance. They have to be they have to be using the property to break the law somehow, using the premises for an illegal purpose, right? Usually you could kick them out for assigning or subletting, but you don't have the lease, so you can't, because it has to be assigning or subletting against the lease. Or waste. No one ever does waste. You can't do waste. Don't worry about waste. Okay. But if they're doing one of those two things, using the premises for an illegal purpose or causing a nuisance, you can kick them out even if you don't have a lease. Nuisance does not mean that you use the F word in front of your handyman. That's not a nuisance. Don't bring that case to me. I can't file it. Okay. But if they are throwing mad ragers, 3 o'clock in the morning, all the tenants are complaining, or neighbors are complaining. We have this a lot where people will rent one of their, nice, fancy $20,000 a month homes, and all of a sudden it's, MTV The Crib, whatever that show was called, I forgot. Cribs. It was just Cribs, right? Cribs. And like every night they're just throwing these huge raging parties. Well, that's a nuisance. Once your neighbors start complaining, you can kick them out even if you didn't have a lease. All right. Also, another question I get with nuisance is pets. Oh, the lease says they can't have a pet, and now they have a pet. Can I kick them out? Technically, sure. Practically, no. Why? Because when we send the 3-day notice to cure or quit and say get rid of your pet, they're just going to give you back what's called an ESA letter, okay, an emotional support animal letter. This is a bullshit piece of paper that anybody can get online for $50 from your local, psychologist who went to school and God knows where, okay? And once they send that to you, that's it. You're done. You can't enforce your no pet provision. You can't charge them a pet deposit. That's it. Now, does that mean a person with an ESA letter can do whatever the hell they want with their pets? No, they still have to comply with the same rules that anybody else would comply with if they had just a regular old pet, right? So that means when someone says, "Ooh, I want to bring my emotional support crocodile into the apartment," no crocodiles in the apartment. I don't care if it's emotional support. If they want to bring their emotional support pit bull into the apartment, right? And the pit bull is like snarling at everyone and they can't even keep him off the leash because he's going to bite the handyman or bite the next door neighbor's 5-year-old. Is that okay? No, he's my emotional support pit bull. No emotional support angry dogs who are foaming at the mouth. That does not work. They still have to follow all the regular rules. Okay, that could still be a nuisance, but it has to be a problem with the dog is doing somehow. It can't be just that they have a dog. So someone has their little chihuahua that doesn't make any noise and is just hanging out with them in the apartment. Sorry, you're out of luck. So to answer your question, Tony, it's really difficult to figure out. They have to essentially follow just the basic rules. And if they're paying the rent and they're not burning the place down, you're kind of stuck with them.
I had a follow-up question in regards to that. So let's just say, we know the amount of tenants that's living there, right? And all of a sudden they have unauthorized tenants in there. Is there anything the owner can do in regards to that? Or are they just gonna have to say, hey, you know what, let's just sign a new lease, put the amount of tenants that's in there and kind of figure out from there on? Or
you could do that, and that sounds very nice theoretically, but why would this tenant sign a new lease? He'd have to be a moron, right?
Yeah, unfortunately, I mean, they haven't signed one yet, but that's what I was gonna do to kind of talk to them on behalf of the owners and see if they're willing to sign a new lease just to kind of set up the new terms and conditions.
Spoiler alert, they're not going to sign your lease.
I highly doubt it, but it is what it is. It's worth a shot.
They're not going to sign your lease, and there's nothing we can do about unauthorized occupants because unauthorized by whom? How do we know what's authorized and what isn't authorized if we don't have a lease? So the only thing we can do is if they get to a level of ridiculousness, like having 17 people in their apartment building and it's just not safe, then you can call the housing department on yourself, which is a last resort. Do not call the government on yourself until you have nothing else to do, right? But if they have 6 people living in their apartment, 7, even 8, nothing you could do.
Sounds good. Appreciate it.
No problem. All right. Is it?
Casey's question comes up a lot. Like people ask, like, should we just sign an 11-month lease and then sign a new lease in 11 months?
Doesn't help you in the city of LA. That's a 1482 trick, which is really good because 1482 protections don't kick in until someone's been living there 12 months. LA city protections kick in right away. So it doesn't help you. Someone else? Follow-up question? No? Okay.
Hello?
Since we Okay.
I have a question.
Okay, go ahead.
If you're a tenant, you have a tenant who.
Sherry, if that's you talking, we cannot hear you.
Oh, wow. I can't, can you hear me now?
Yes.
If a tenant has a sister who moved in with her for 12, have been living there 12 years.
No, we lost you. We lost you after sister.
And the sister's in a restaurant now. Can they put the sister out, the sister's sister out? In other words, she's a tenant there with no lease. She moved in with her sister. Her sister is now in a convalescent home. Can the person who...
Yeah, Sherry, maybe type your question because we really can't hear you. It sounds like you're reading back my order at Wendy's.
Okay.
Sorry, Sherry.
Hi, Anthony. Oh god. Okay, I'll type it in.
Finally laughed. I've been telling jokes for like an hour. Nobody's laughing. I said Wendy's and everyone just burst out. Okay, now I know the audience. All right, food jokes. Good. All right. Jesse says, since we don't have the opportunity to have someone explain this stuff every day, thank you for this. Is there a resource that summarizes all the details of new bills in layperson's terms? Yes, there's a resource that makes my job completely obsolete and makes it so that you can know everything I know. I'm sorry to make fun of you, Jesse. No, there's no such thing. Because number one, it would be impossible to summarize all of this. Number two, they change it all the time. And sometimes they change it in the middle of your case, right? And were we recording when I was telling that story?
Yeah, it's been.
Okay. So you guys heard, they change the rules all the time. They don't like the way we got around them. They'll just change them. And not every year, like multiple times a year, right? So, and then every city has its own, and every city is now, not every city, but a lot of cities are adopting their own rent control laws, and they're slightly different than everybody else's, right? Pasadena went from having no rent control, no eviction control, to having one of the most punitive, like up there with Santa Monica and West Hollywood, rent and eviction controls, right? Overnight, in a day. And so it's very difficult. I will tell you just from personal experience, it is very difficult to keep up with this stuff. And by the way, funny story about Pasadena, they made little rules that said, you have to use our forms when doing this and this and this and that. We're like, okay, where are your forms? They're like, we haven't made them yet, but you have to use them. So we have to use the forms that don't exist yet? Yup. What are we supposed to do with that? They're like, your problem, not ours. So believe me, it is very frustrating. Don't bother trying.
So it's 6 o'clock, but maybe if you want to scroll through and answer
Sure.
one more question, whatever one you think is maybe most helpful.
Okay. Sandra, you don't have to give the exemption. Yes, you do. You do have to give the exemption. If you want to do the 10%, you do have to give the exemption. Okay. Okay. Susan says she filed for eviction for a family occupancy of tenants who said $100K buyout was not enough to get them to go. LHD suggests to wait until their relocation is made before serving the 60-day. That's not how that works. And the tenants can still sue, fighting the eviction for procedural reasons. What procedures, forms, document must I follow to make sure eviction is sound? You need to call me. That's pretty much it. It's complicated. And unfortunately, we don't have time to go through it, but I'm happy to help your clients. Don't call the LAHD and ask for legal advice, because they're not there to help you. They're there to hurt you. The way it works is that you serve the declaration with the 60-day notice on the city and the tenant. Later on, the city's contractor called Interwest will mail you or email you the determination of how much you actually owe them. But it's never going to be more than $25,000. That's the max. So if you're doing an eviction for family occupancy, the tenants are just trying to be grifters. They're not entitled to 100K. They're entitled to 25. They want to stay there and force you to do a UD. By all means, do a UD. They're still not going to get more than that amount of money. Maybe a little bit more to, get the UD to be a little shorter, but there's no way they're entitled to 100K. Okay. I think that's everything. Yeah, any questions here? No? Good. All right.
Will you type in your contact
Sure.
info in here? Niv's gonna type in his.
I'll do it for you, Niv. Don't worry, I got it.
Got it?
Yep.
Okay, so again, thank you guys so much for coming. If you're a realtor, what's your broker doing? What's your office doing? Are they doing high-level education like this? If not, we would love to have you join us. And we promise to protect you. I see you smiling, Craig. Come on, you're close, right? We would love to have you join us, and we have your back as far as education and everything else. Will, any closing thoughts from you?
No, thank you, Niv, as always. It's always great to hear you speak. I use Niv personally. If that tells you anything, I'm a property manager. I'm an owner as well. You want to go with the best. You can clearly see that he knows what he's talking about. It helps you on the brokerage side, helps you on the landlord side, and it helps you on the development side as well. So, I would highly recommend him, as I'm starting to put in his information. Oh, there it is. Okay. Yeah, I would say, come back. Obviously, every month we're going to hit some other new topic, but this is obviously one of our most popular ones. So thank you again, Niv, for coming in.
My pleasure. Thanks, everybody.
All right. Thank you guys. Have a great afternoon. I'm going to leave the chat open just for a few more minutes in case you want to talk, and we can hang out here and talk a little bit more, but I'm just going to mute it so we won't hear you. But have a good day, everyone.
You too.
Thanks,
Thank
everybody.
you. Thank you.